withdraw cash or deposit cash. Only I have to verify the statement made by the cashier.
Let us see.
My lords, on 18th, my lords. On 17th is in Delhi, my lords.
Alage.
In Supreme Court, that's why, my lords. Any day after 18th, my lords.
11, 12, 13. 13 holiday.
ಅಲ್ಲ 11th 12th 13th ಇಲ್ಲ 15th 16th ಯಾವ ತರ
15
Monday, my lords.
Monday.
16th Tuesday.
My lords, Tuesday also is not there, my lords. Tuesday and Wednesday is
Monday,
humble
Monday.
request, my lords.
15th yes Monday.
Obligement.
Yes.
Grateful, my lords.
Objection is filed.
Yes, my lords. It's been
Objection
filed.
also filed.
Yes.
Number 62 adjourned. Cell number 63 Chandrakant Argole per petitioner.
63 ready, my lord. Filed in lord. This is a pleasure
For the-
of appointment, lord. Where
For the petitioner in this matter, my lords,
Yes.
I was terminated without conducting an inquiry. The petitioner was appointed as a commandant on 26/7/2021, my lords. In fact, I left with one year 3 months service, my lords.
Now
And-
where is your appointment order?
My lords, Annexure A may kindly be seen, my lords.
Yes. Read.
page 18.
Page 18, my lords.
Yes.
ಕರ್ನಾಟಕ ಗೃಹ ರಕ್ಷಕ ದಳ ತಿದ್ದುಪಡಿ ಅಧಿನಿಯಮ 2003 ಪ್ರಕರಣದ 3 ಉಪ ಪ್ರಕರಣದಲ್ಲಿ ಪ್ರದತ್ತವಾದ ಅಧಿಕಾರವನ್ನು ಚಲಾಯಿಸಿ ಶ್ರೀ ಸುರೇಶ್ ಬಾಬು ಬಿನ್ ಮುನಿಯಪ್ಪ ಇವರನ್ನು ಚಿಕ್ಕಬಳ್ಳಾಪುರ ಜಿಲ್ಲೆ ಗೃಹ ರಕ್ಷಕ ದಳದ ಗೌರವ ಸಮಾದೇಷ್ಟರನ್ನಾಗಿ ರಾಜ್ಯ ಸರ್ಕಾರದವರೆಗೆ ಇವೆರಡರಲ್ಲಿ ಯಾವುದು ಮೊದಲು ಸಂಭವಿಸಿದೆಯೋ ಅಲ್ಲಿವರೆಗೂ ನೇಮಿಸಿ ಆದೇಶಿಸಿದೆ. I took a charge as per
Then what is that 5 years is term is
Lord,
as
then
per annex.
what is that 5 years is term is
Lord, 2C, that is very important, my lord. The rule which says,
what is that rule says?
Lord, I have filed an objection, my lord. That may be taken.
My lords, the objection copy is not served on us, my lords.
Copy is not served.
ಅವ್ರು ಮುಂಜಾನೆ ಇಲ್ಲೇ ಇದ್ರು, ನಾನು ಮೆನ್ಷನ್ ಮಾಡಿದ್ರೆ ಟೈಮ್ ಮೆನ್ಷನ್ ಮಾಡಿದ್ರು, ನಾನು ಹೇಳ್ದೆ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ ಅಂತ. ಅವ್ರು ಇದ್ರೆ ಇಲ್ಲೇ ಕೊಡ್ತಿದ್ದೆ ನಾನು. ಬಟ್ ದ ರೂಲ್ ಈಸ್ ವೆರಿ ಕ್ಲಿಯರ್, my lord. That is not in dispute.
No, without serving, how can you file? You have
Lord, may I make one submission, my lord? ಲಾಸ್ಟ್ 2 days ಲೀಸ್ಟ್ ಆಗಿತ್ತು. ಅವ್ರ ಸೀನಿಯರ್ ಹುಷಾರಿಲ್ಲ ಅಂತ ಟೈಮ್ ತಗೊಂಡ್ರು.
ಅಲ್ಲ ನೀವು ಸರ್ವ್
ಈಗಿದ್ರೆ
ಮಾಡಿ
ಕೊಡ್ತೀನಿ, ಇವಾಗ ಕೊಡ್ತೀನಿ. ಬಟ್ ದಟ್ ಇಸ್ ನಾಟ್ ಎನ್ ಇಶ್ಯೂ. ಸರ್ವ್ ಮಾಡಿದೀವಿ ಅಂತ ಈಗ ನಂಬರ್ ಹೇಳ್ತಾರೆ,
ಅಲ್ಲ
ಮೇಲ್ ಅಲ್ಲಿ ಕಳಿಸಿರ.
No, my lords, it is not served on us, my lords. In fact,
ಆಫೀಸಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಬೇಕಲ್ಲ if it is not
ಮೇ ಬಿ
served.
ಟೇಕನ್ ಟುಮಾರೋ, my lord.
Wait.
ಸ್ಮಾಲ್ ಇಶ್ಯೂ.
Yes.
my lords, kindly have it next week, my lords. We will.
Office of the Advocate General. ಎಲ್ರಿ ಕೊಟ್ಟಿರೋದಕ್ಕೆಲ್ಲ ಐತ್ರಿ. Office objection has not been raised. Yes, what is that rule says?
Lord, may I read rule, my lord, last page, my lord, that is at page 39, 2C. ತಾವು page 40 ಬಂದ್ಬಿಟ್ರೆ, sorry, my lord. 2C is at, may I read, my lord?
40.
Page 41, my lord.
Yes, 2C,
Annexure R6, that is the 2C, subject to the pleasure of the state government term of office of the.
Yeah,
My
no,
submission is let them serve the copy. We will rectify and we'll make our submission.
no,
However,
this is a law. It is not that even if it is served or not served.
Lord,
This,
even otherwise.
no, my lords. However, the inquiry has to be conducted as per the
There is
rules,
very
as
clear,
per
not
their own rules, my lords.
Nothing is required. Nothing is required for removal of any. The doctrine of pleasure is there, my lord.
no, this is related to what?
Doctrine of pleasure, judgment.
No, this related to what?
My lord, this is in respect of appointment of under the Waqf Board Act, my lord. That's
is
the same. The word used here, that is a pleasure of.
No, that constitutional bench of Supreme Court has decided.
lords.
We are going to decide all these matters. See, political appointment, nomination, arbitrarily entered, he has to go by arbitrarily.
Obliged,
That's
no.
what
That is-
Supreme Court said.
The entire
See,
ground is that.
all
my lord.
this is concerned, you have a pleasure, but there should be a reason.
Two
Here,
allegation, my lord. One is
enough. One
political
allegation-
involvement. Another is that he has misused the petrol where.
No, if even you need not disclose in that order, if file says some allegation is out.
The report is called for. Report says that he has
That
done
is,
that.
that is more than enough. Yes, madam.
My lords, weeks time may be granted. We will. look into it,
You
my lords.
come and collect today. We will have it on
Please.
day after tomorrow.
Obliged, my lord.
My lords, kindly have it on next week, my lords.
Not next week.
The word used as pleasure in this statute, my lord, that this court has held that.
Even if it is not used or not there, Supreme Court has considered that doctrine of pleasure, then subsequent judgment also. See, nomination, political reference, it is for the party who has nominated.
I agree, my lord.
for their purpose, they can remove that. But here, without any reason, you cannot be.
But even
removed.
there
Now
are
it
two
is-
judgments, Lord, in respect of appointment of law officer. That is that they say that he cannot challenge because it is a doctrine of pleasure. You should go when.
Even law officer is concerned, it can be removed because it is for that government this thing.
ಇದ್ರಲ್ಲೂ ಹಂಗೆ ಇದೆ.
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ಇವರು
This
command.
statute is very clear.
In appeal, my lords, appeal was allowed, modified to, my lord, reduction in time scale of pay by 2 stages. And it was held that, my lord, until I report, it will be treated as dies non. But while communicating, my lord, the disciplinary authority said that I have to report at Sakleshpur. And, my lords, I challenged all the orders before this honorable court. My lords, your
Now,
lordship,
why it is urgent today? On that day, you
your
have-
lordship, my lords, raised early, my lords, on that.
Yes, now you argue here.
Please,
Yes,
my lords, the
just give that brief.
Please,
time.
Lord, sir.
Yes.
My lords, the fact, my lord, stating that, my lords, I am, my lords, I was secretary of a trust which was running a school.
Yes,
Though being an employee of the LIC,
yes,
I was proceeded against, my lords, by holding disciplinary proceedings.
yes,
Page number 132, my lord, the order of the disciplinary authority. Relevant would be 133.
yes,
Last paragraph, my lord, the penalty was removed from service. And this was passed on 19 to 2015.
yes, 19 to 2015.
2015.
Yes.
My lords, I preferred, my lords, in
Yes, 19 to 2015.
2015.
Yes.
My lords, I preferred, my lords, in appeal.
Yes,
This was, my lords, by the senior divisional manager, my lords, also the disciplinary authority.
yes,
In appeal was preferred against this.
yes,
My lords, you may have a look at annexure Y, my lords, starts at 158. Relevant would be 163. The
yes,
same was converted to reduction by 2 stages in the time scale of Bay, applicable to his cadre. In persons of this order will be treated as dies non. Lords, the disciplinary authority who was
Date of
required to
removal.
communicate this annexure Z, my lords, passed 164. Second paragraph, he said that I am enclosing this order. And then he said, according to the instructions of the competent authority at zonal office, you are hereby posted to Sakleshpur branch office as typist. Hence, you are hereby advised to report for duty on or before 5/12/15.
yes,
Then he said, I have to resign. My lords, I represented and said, next document, my lords, annexure AA 165. Para 4, my lords, I specifically said that I am at Mysore. My family is stationed at Mysore. Please allow me to continue at Mysore. Lord, this was not considered, my lords, next document 169. The authority said, with reference to the disciplinary authority, my lord, with reference to the above, the undersigned has examined your above request.
Page,
And
page.
that is 169.
yes.
Said not possible to accede to the same.
Hmm.
Then, my lords, I made representations, then inevitably I approached this honorable court by filing. Then, my lords, I made representations, then inevitably I approached this honorable court by filing WP, my lords, 177 is the order passed. My lord, 2 petitions were clubbed.
Yes.
One relation to, my lords, the payment of, my lords, the arrears which I claimed, that is WP 45111 of 2015. And the order of the disciplinary authority as well as, my lord, the appellate authority and subsequent orders of the disciplinary authorities were challenged.
Yes.
In WP 58361 of 2016. Lordship may kindly come to, my lords, the paragraph number 17, my lords, at 200. The lordships stated, my lord.
Yes,
The other contention of the learned counsel that the appellate authority could not have imposed penalty of reduction in time scale even does not merit consideration, as it was the appellate authority taking a lenient view imposed the said penalty. The disciplinary authority no doubt has travelled beyond what the appellate authority has ordered, that too quoting on the instruction and directions of the competent authority. The respondents have filed their objection but have not placed any instructions given by the competent authority to direct what the disciplinary authority has ordered. Therefore, that part of the order of the disciplinary authority is rendered unsustainable. However, it would be open to the disciplinary authority to pass appropriate orders in accordance with law. Then W so and so, which was the other petition, notes was disposed of as infructuous. Then 2, the present writ petition, which was there, which I preferred against the orders, which was allowed in part. 3, my lords, would be important. Petitioner shall be entitled to all consequential service benefits that would flow from the obliteration of the aforesaid orders at clause 2. Those orders are the orders of the disciplinary authority which I read to your lordships now, saying that I have to go and report at Sakleshpur. Consequence of this would be, my lords,
No, see,
please.
you have been imposed penalty on the same order, it has been directed to go and report. to
First,
the-
my lords, was the order of removal,
Hmm.
preferred an appeal. Appeal, it was modified as a reduction by 2 stages. While communicating the order of the appellate authority said, I am forwarding the order to you. I am also instructed that you should go and report at Sakleshpur.
No, that is not the penalty.
No,
Yes,
that's
ma'am.
what I treat, my lord, that is the case here.
Madam.
I asked, 1 second, sir. I was asked to go and report at Sakleshpur. I did not go. My lords, I preferred the writ petition was contesting the matter before this court. During the course of hearing, my lords, before this court. During the course of hearing, my lords, the issue of my lords, voluntary retirement, my lords, also cropped up. I said I'm ready to take voluntary retirement and go. My lords, may have a look at my lords annexure AS, my lords, the last annexure. Probably it should be 235, my lords.
Yes.
That is, my lords, the order dated 18/9/2019
Hmm.
of this honorable court.
Yes.
Lords, two orders I'll read, 18/9/19 and 17/7/19. First, I'll read 17/7.
Yes.
As an interim measure, the petitioner has pointed out that the respondents are reluctant to accept option relating to pension of the petitioner on the score that the petitioner has failed to report at Sakleshpura. Learned counsel for the petitioner on instructions submitted that the petitioner would be reporting at Sakleshpura within 2 days. Since Saturday, that is 27/2019, is the last date for submission option for pension. Therefore, concerned respondent is hereby directed to accept the petitioner's option for pension in the event of petitioner reporting to Sakleshpura subject to result of this petition. My lord, this is important. Then, my lords, 18/9 order. Learned counsel for the petitioner submits that the petitioner is willing to tender application for voluntary retirement subject to respondents withdrawing the punishment imposed. Learned are, my lords, to be, will go as it will be obliterated.
But interim order is granted on 17/7/2019.
Yes.
When is that?
My lords, 18/9/19 would be relevant.
18?
9/19. My lords, on the top, my lords. Same page, my lords, on the top.
17/7/2019.
My lords, above that, my lords, 18/9/19. Above that,
Yes, 18/9. Yes.
ಅದರಲ್ಲಿ last paragraph. Be that as it may, it is open to the petitioner to submit a request for voluntary treatment if such the same shall be considered and disposed of in accordance with law within outer limits so and so. The consideration shall be subject to, without reference to the pending petition. Then 17/7 ಅಲ್ಲಿ, the court said, therefore, concerned, second paragraph, the concerned respondent is hereby directed to accept the petitioner's option for pension in the event of petitioner reporting at Sakleshpura subject to the result of the petition.
Hmm.
Lord, it was made subject to result, my reporting was subject to the result of the petition. The order was
Therefore,
passed.
even interim order also says that you go and report.
Yes, I reported that there is no dispute. I reported that there is no dispute. I reported in pursuance of this. Then my lords, I returned on voluntary retirement. When the order was passed by this court, final order, page number 201,
Asking that,
please.
when that penalty order has been passed to ask you to go to the Sakleshpur.
My lord, that is not a penalty. That's what I said. My lords, that is while communicating the order of the appellate authority, the disciplinary authority said,
No, that's
I am
what-
instructed, you go and report there.
I'm asking that what is the date?
My lord, that is what I read, my lords, annexure Z, dated 21/11/2015.
21/11/15.
2015, the first order.
Yes.
2015, my lords, the first order. The second, my lords, on the represent.
Now that I will come to that, Mr.
Yes,
21/11/2015, you have been asked to go to that Sakleshpur.
yes.
Then,
The next order, my lords,
when did you report it to the Sakleshpur?
that is, my lords, after the interim order of this court.
Hmm.
That is,
That is on 17/7, maybe 18th or 19th.
yes.
19/7. 19/7/2019,
Please.
there is no any order saying that to, not to report to that Sakleshpur.
No.
You have not
There was
reported.
no, that is what my
No,
lords,
just because challenging before this court,
my lords, I'm not on that. I'm, my lords,
do you succeed?
I'm drawing, my lords, I'm not on that. I'm, my lords,
Do you succeed?
I'm drawing, my lords, the support from the observations of this court in the final order passed. Let me go back to, my lords, the final order of this honorable
No,
court.
that is what that.
Please, final order of this honorable
No,
court.
that is what that.
Please,
Suppose if you are in the work, if the final order has been passed,
please.
then you have to be come back from the Sakleshpur. Till then, order has to be complied.
Correct. That's
Yes.
what no, that's what I am trying to say, my lords.
So
I am-
see, if you are been transferred, 4 years transfer case has not been decided. After 4 years, court has
My lords,
decided.
my lords,
You say, I will not go to the transfer.
let my lords, my lords, I draw.
And there was
One
no
second,
interim
sir,
order
please, I have
also.
not finished, sir.
Let him argue.
My lords.
that. First let him come, then I will ask you.
That is,
But yes.
my lord, that's what, my lords, I am trying to, my lords, make, my lords, stress on the final order passed.
Yes,
If I am permitted to go back to the, my lord, the order portion,
yes.
para 18,
Page,
my lords, 201.
yes. Yes,
That is two, my lords.
Yes.
WP 58361 of 16
Hmm.
is allowed in part. The orders of the disciplinary authority dated 21/11/15 and 19/2/16 stand quashed.
yes,
Petitioner shall be entitled to all consequential service benefits that would flow from the obliteration of the aforesaid orders in clause 2.
Hmm.
My lord,
what is that meaning?
yes, my lord, that's what I tried to, my lord. On the other day, my lords, I tried to rely upon, my lords, a decision of the Honorable Supreme Court. My lords, which I also passed on, my lords.
ಇರ್ಬೇಕು.
The last paragraph, my lords, if I'm permitted.
Which is that judgment? It is there.
My lord,
2015.
Yes, my lord.
Hmm.
So, Nimshika. The last paragraph, my lords, if I'm permitted. Yes. Para 20. Your lords may kindly come to the head note itself first.
Yes.
That is head note E, my lords, at page number 612. What happens when an order is converted? From which day, my lord, it comes into effect? My lord, the head note E itself says,
That means to say, if you are not worked for 2 years, you want that to be paid.
my lord, that's what this court said. Consequential benefits arising out of obliteration. It's as good as that order is not there. My lord, my ultimate, my lord, the submission is this. I would have joined. I said I'll go and join. Please change it to Mysore.
No, see, till then, you have to be obey that.
No, that is not, that's, the, my lord, this court
If you are
said, this court did
transfer-
not.
No, that's what I am asking.
Please.
When you are transfer by transfer order,
Yes.
you have challenged that I cannot be transferred there. Case has been decided after 4 years, you are
Yes.
not reported that. Do you mean that you are entitled for all?
My lord,
salary?
my lord, the final order of this court.
Supreme Court said, I think first you have to be
My lord,
reported to
that
that
is,
place.
that is
then you have to
not,
be
that is,
challenged.
that is the distinction here.
Yes.
What I am trying to say, my lords, if the courts, my lords, if the disciplinary authority said, you are reinstated in persons of this, then he would have said, no, you go to, you are transferred from Mysore to Sakleshpur, that in persons of this. Then he would have said, no, you go to, you are transferred from Mysore to Sakleshpur, that's a different issue. That's what this court said. My lords, they could have passed another order asking me to go and, in fact, my lord, they passed another order, my lord, directing me to come back to Mysore later on. Then I retired in Mysore. That's a fact. My lord, they could have done it, my lords, which they did not do it, my lords, for their own, my lords, it is left to them.
Yes, yes.
But my lord, fact is that I stayed there for some time. Then I came back to Mysore and retired on voluntary retirement. This honorable court said that is gone. And you are entitled to unconsequential benefits. Now, my lord, that order is not challenged. That has become final, my lords, and binding on the other side. Now, when that is so, the law is that I am entitled as if it was not there. I was prevented, my lords, from discharging my duties.
No, nobody is prevented.
Yes,
If they are-
by the order of the disciplinary authority, my lords, I was asked to go to and
No, yes, that is, see,
that order is gone.
no, if somebody is prevented to work in
If-
Sakleshpur, then
No, if at all this court said, my lord, if at all this court had said, say, my lords, that order is bad. Anyway, you did not report to duty for this period, you will not be entitled to the other leaves, then it's a different thing altogether. But this court said you are entitled to all the benefits for obliteration of that. Obliteration means it is as good as not there.
Yes.
My lords, when it is not there, when it is, my lords, a
All
void order.
contractual service benefit. Yes.
If at all, my lord, the court had stopped it, my lords, the consequential benefits, my lord, it's a debatable issue. It says because of the obliteration of the orders. That means to say those orders are gone.
Two petitions you have challenged. One
Yes,
is
first order, my lords, is about, my lords, some for the, my lords, payment of salary for a certain period, which they paid late after, my lords, I filed the petition. I wanted an interest, this court benefits arising out of such obliteration.
Yes.
When that is so, my lord, from which state, my lord, the same has to be paid is the issue. My submission is, because I was prevented by asking me to go on Sakleshpur, reported Sakleshpur, though I said I'm going, ready to report it to Mysore, I was prevented, my lords, from reporting in persons of the order of the appellate authority. That was, my lords, frustrated, my lords, for some time. When that is so, I'm entitled for, my lords, all the benefits is my case. What this court says, my lords, in 2015 2 SCC, my lords, the decision which I referred to, your lordship may kindly compare at 24, my lord. Where, my lords, the order of, my lords, the dismissal is modified as a compulsory retirement, para 25. The last contention is with regard to the date of effect of punishment. According to the respondent, even assuming that the compulsory retirement is to be imposed, it could only be from the only with the effect from the date of the order, that is 28/2/2000. We are unable to appreciate the contention. The respondent should dismiss from service as per order date 10/6/97. It was that punishment which was directed to be reconsidered. Consequent upon punishment which was directed to be reconsidered. Consequent upon thereupon only, the punishment was altered, substituted to compulsory retirement. Necessarily, it has to be from the date of dismissal from service, that is 10/6/97. That is, my lord, the date will go back to, my lords, that order itself. Not that, my lords, it will be the date when I report is my submission. My lord, my lords, on the other day, in respect of other case also, I made a submission, my lords, that the Honorable Supreme Court has said the meaning of consequential benefits. Lordship may permit, my lords,
the consequential.
what
service
does the mere order of reinstatement, having considered the submissions advance at the outset, we make it clear that we are not entering into the merits of the matter, that is the reconsideration by the High Court in the full court meeting held on so and so, and the termination letter issued by the state on 2/4/24. These orders could be tested before the High Court by way of a fresh writ petition to be filed by the appellant, and such liberty having been granted by this court in writ petition under Article 32 of the Constitution of India, filed by the appellant, which was withdrawn on 22/9/2023. For the above reason, the case laws relied upon by so and so not being dealt with, nor are we dealing with the case laws relied upon by so and so. Then, my lords, para 21. Once the termination order is set aside and the judgment of the High Court dismissing the writ petition challenging the said termination order has also been set aside, the natural consequence is that the employee should be taken back in service and thereafter proceed with as per the directions. Once the termination order is set aside, then the employee is deemed to be in service.
No, that is settled. See,
No.
Therefore, employer
Yes.
himself has restrained you from work because of the termination.
Otherwise, my lords, otherwise, I would have, my lords, in normal course, I would have reported at Mysore
You have
and,
not been terminated, you have not been restrained.
no, that
But
is,
the thing is that
please.
this court has directed to give all consequential benefit. It is not denied that benefit which he has not worked.
My grievance,
Because denied that benefit which he has not worked.
my grievance,
Because when it is disposed of, you have also not brought to the notice he has not worked. Court has said that give all consequential benefit. Unless it is you get it clarified or
and
you
my lords,
challenge.
I'll read their endorsement, my lords.
Now see that finding has been given by the court that your order which is.
Their endorsement, my lords, which was given, my lords, after my representation was made. Annexure 80, page number 230, order of this court. I made they communicated, my lords, this to me, saying that, see, this has been modified. Lords may kindly come to, my lords.
2/11/2015,
Yes.
when the writ petition is filed on the same year.
My lords, 165, my lords, 30/11/15. I make a request at para 4. 166.
166,
Para 4.
Yes. Yes.
I say, however, at this stage, I am issued with a letter dated so and so by yourselves that I have to report at Sakleshpur branch office and should report to duty honor before so and so. And I am advised to resign from primary membership of the trust and the post held by me. And that I am also advised to desist from the activities relating to the trust in future. Insofar as these issues are concerned, I deem it appropriate to state the juncture. The present order dated so and so is passed during the middle of the academic year, and I am the only breadwinner in the family. And in the view of the fact that my children are studying in 5th standard LKG at Mysore, it would be difficult for me to move right now to Sakleshpur. It is also required on my part to inform you that my wife is a home so and so. To inform you that my wife is a home so and so. My lords, I said, please allow me to continue at Mysore.
Yes.
Then, my lords, they rejected it. Your lords may come to page number 170, my lord. That is another representation.
Immediately you are challenged before this court.
Then, my lords, they said not possible. Then I came before this court. And after,
What is the reason for this court to say he is entitled for all consequential benefit? Is that because he has not allowed to work in that Mysore, therefore he is entitled. Otherwise, why that word has to be used by the court? How can you say that it is in a same writ petition?
Murder.
See, after that order passed by that earlier writ petition,
Yeah.
you have issued this endorsement, is it not?
Yes.
That he has challenged by filing this writ petition.
He is asking for the salary for which he has not worked.
No, but this court has granted to give him
No, no,
all
no.
consequential benefit.
Kindly see page 163, madam. That is the order of the appellate authority. This has not been set aside.
160?
163.
Yes.
This is the order of the appellate authority.
Hmm.
He admits it. What is the order? He admits it.
What is that appellate authority as?
Kindly see last para number.
Hmm.
Now, therefore, by virtue of the powers vested in me under regulation so and so, LIC of India so and so, I do
No.
hereby order.
Z, annexure Z,
Annexure Z hindgade.
160.
163 page. This is annexure Y.
Yes, yes. Hmm. Hmm. And
No.
so also aforesaid regulation is also ordered that period of his absence from the duty, from the date of removal to the date of his resumption of the duty in pursuant to that order. See, he wants to report to the duty immediately after this in Mysore. You said that go Sakleshpur. That is what he has challenged that, Mr.
Murder.
Yes, that will consider. Yes. He has been restrained to work in that Mysore in terms of that order passed by the appellate authority by your employer.
This
They said,
this
go-
order.
they have not said go to the Sakleshpur.
Yes.
See, he has to go and report means the place where he has dismissed from the service where he has to go.
Murder. That is
Then
final order passed by the appellate authority is upheld by the
all
this
consequential
honorable court.
service benefit, Mr. All consequential service benefit. The specific word is used that
Yes,
all
only-
consequential service benefit which is flow from that impugn order.
Murder. That is correct, murder. But the order of
Order
the
you have not challenged. Now you can't.
the order of the appellate authority is upheld in the writ petition.
According to that appellate authority, you are not allowed him to report duty in that Mysore. You are directing him to the go Sakleshpur. This court said that you have no authority
No,
to
no,
ask.
appellate authority has not ordered to report to Mysore at all. There is no reinstatement at all in the appellate authority order because they
Ultimately-
have been passed in the Hyderabad office.
This court has said you have directing him to go to the Sakleshpur is contrary to that appellate authority order. What is that meaning? That order is final. You are not challenged. Why that order you have directing to report the Sakleshpur has been quashed by this court after giving clear finding?
Because kindly see the annexure judgment.
That means to
That-
say
that is-
what
that
is
is-
not ordered by
that
the
is set
appellate
aside.
authority, you have ordered it.
Annexure
Hmm.
that was the posting order only.
ಅದನ್ನೇ ಇರದೇ ಇಶ್ಯೂ ಇಸ್ ಪೋಸ್ಟಿಂಗ್ ಆರ್ಡರ್.
ಹೌದು.
ಪೋಸ್ಟಿಂಗ್ ಆರ್ಡರ್ ನಿಮ್ ಸಕಲೇಶ್ಪುರಕ್ಕೆ ಹೋಗಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅಪಲೇಟ್ ಅಥಾರಿಟಿಯಲ್ಲಿ
Trust. That is why it is not correct ಅಂತ it has been squashed.
ಸರ್ವಿಸ್ ಬೆನಿಫಿಟ್ ಏನ್ ಬಂತ್ರಿ ಅದರಲ್ಲಿ? ಸರ್ವಿಸ್ ಬೆನಿಫಿಟ್ ಬರೋದೇ ಫಸ್ಟ್ ಪಾರ್ಟ್ ಅಲ್ಲಿ. first part he has been asked to go to the Sakleshpur has been passed, is it not?
Yes.
Is it not? There only service benefit will come. What is that service benefit will come in that he is a membership of trust?
My lord.
Nothing will come there.
According to me, my lord, the appellate authority order is not set aside at all.
Yes, yes.
It is prevailing. So the, this portion, I also order that the period of his absence from duty from so and so, removal 19/2/2015 to date of his resumption to now he has reported for Sakaleshpura. That has not been set aside at all. Moreover, my lord, his prayer is not allowed at all. Kindly see page 185, my lord.
No, you see that order of this court, Mr.
That is
Earlier
correct,
they
my
have
lord.
specifically-
Kindly see page 185, my
No,
lord.
Mr. You are
That
not
is the,
challenged.
that is the prayer.
He cannot dilute that earlier order passed by that other bench to say that this is not correct and all. If you want, you earlier order passed by that other bench to say that this is not correct and all. If you want, you could have been challenged or you could have been sought for a clarification. Otherwise, court has specifically stated that you have to pay all consequential benefit. Therefore, after quashing, directed to pay consequential benefit means he is entitled for all, even whether he served, he has worked or not, you have to pay. If it is already worked, you need not be directed to pay that salary, is it not?
Yes.
In this writ petition, petitioner has called in question impugn endorsement by annexure 80 dated 28/2/2024, rejecting the request of the petitioner payment of salary from 19/2/25 to date of assumption of the duty, that is 19/7/2019,
Yes. 19.
and that period has been treated
19.
as dice non.